Good morning. My name is Chris Newman. I teach copyright law here at George Mason. We're ready to start our next panel. So this morning we started with a discussion of economics, and there are a lot of people out there who want to assert that if you're going to discuss IP policy, you're not allowed to talk about anything other than utilitarianism and economic justifications. Interestingly enough, exactly 1 week ago on this very stage, we had a lecture by Israel Kirzner, who's a leading Austrian school economist and shortlister for the Nobel this year, who was asked from the audience whether his economic theory supports protection of IP rights. His response to that question was, that's not an economic question, it's a moral question. So we now have a panel to discuss the moral question. We're going to start with two law professors, Eric Clays, here from George Mason, and Mark Schultz, who you've met earlier, who's a law professor at Southern Illinois and one of the co-directors of CPIP. They're going to try to provide a little bit of a more of a theoretical perspective on the possible links between normative principles and IP protection. And then we're going to follow and hear from two people who are actually have more of a lived experience in the trenches, if you will, of being creators and innovators and how these principles actually play out in practice. In that vein, we're going to hear first from Ken Anderson, who is the founder and CSO of the technology startup Thermaquatica, as well as a professor of geology at Southern Illinois University. And batting cleanup, we're going to have David Lowery, who's a professional singer-songwriter, best known for his work with the band Cracker, as well as being a lecturer at the Terry College of Business. So with that, we're going to first hear from Professor Clays.
Thanks to Chris for the introduction, and thanks to Adam and to Mark and to Matt for inviting me to talk. Before starting, I want to leave my back door open. I don't consider myself an IP expert. I consider myself somebody who knows a lot more about property and about labor theory. But I do know a little bit about IP, and here in particular, the things that I know about property let me know a little bit about remedies. And remedies, I think, are something that are very relevant in IP. And they provide one place where you can talk about the common ground of different kinds of IP. Richard Epstein asked in the last session whether the cases for patent and copyright and so on are different. I have no doubt that they are, but doctrines like the subject matter exclusions for laws of nature and patent, or the fair use doctrine and copyright provide the places where you can see how patent and copyright differ in their substances. Once you know what you have a valid property right in both cases, the remedy principles that apply in both converge or are a lot more similar, and that'll be the focus of my talk today. So the talk is about the common moral case for injunctive relief. And I am responding in this talk and in a paper I hope to publish to tendencies in IP law and IP scholarship to pick around the edges of the property rights in IP using remedy principles. And my main target will be some passages in the eBay case handed down about 8 years ago now. And I want to focus on two particular themes in the eBay case. One, a suggestion by Justice Kennedy that NPEs, non-practicing entities, don't deserve injunctions, and another that injunctions need to be limited in cases where there's a holdout of several patents. What I want to do in this talk is to present a focus, a labor-based case for the property in patent and copyright, and show how a labor-based case for property relates to remedies, and in particular to show how remedies protect, calibrate, and implement the substance of labor-based property rights. And I want to suggest at the end that a lot of the criticisms of non-practicing entities are misguided, and the concern that's being bandied about here is really more about paper patents or corresponding copyrights that aren't used in any sense whatsoever. Non-practicing entities is kind of a misguided focus. And I also want to suggest that holdout's something that is a legitimate concern, but one has to be careful to protect the commercial interests of owners in making full commercial use of the IP that they hold. And so what I'll do in my time here is just to explain some of the remedies issues in IP law, give a quick and dirty overview of labor theory, then try to explain how labor theory applies to IP, and then come back to these implications for the issues raised in eBay. So remedy materials, and here I'm distilling slides that I distributed in the CLE materials, but the eBay case listed 4 factors that are relevant to determine whether injunctive relief ought to be granted when a plaintiff is suffering an ongoing infringement. The first is whether the plaintiff is suffering an irreparable injury. The second is whether the plaintiff has adequate remedies at law. A third then asks whether the hardship of not granting an injunction to the plaintiff outweighs or is outweighed by the hardship to the defendant of having an injunctive thrust on him or her. And the last is the effect of any injunction on the public interest. And the the court opinion specifically said that these factors are relevant both in copyright and patent, and I'm going to assume as much here today. Now, there's a tendency in all property law that when there's some ongoing taking of property, that by itself creates some kind of rebuttable presumption for an injunction. And that idea has come into criticism, and it came into criticism in the eBay case. And it's also come into criticism more recently by President Obama himself. He has talked about patentees who don't actually produce anything themselves. But in the eBay case, Justice Kennedy singled out an industry in which firms use patents not as a basis for producing and selling goods, but instead for obtaining licensing fees. And he thought that that fact situation ought to be relevant to deciding to withhold an injunction that might otherwise enter. And he also worried about the possibility that a patented invention would be a small component of one product and the threat of injunction would be used to get undue leverage. And I want to warn here that remedies aren't the sole determinant of property rights, but remedies vindicate rights. Remedy principles also specify rights. Rights can get overbroad, and remedies provide one place where rights can get limited to their proper bounds. And so there's a Goldilocks problem here. You can't have too much or too little property. You have to have just the right amount of property. You can't have too much or too little injunctive relief. You have to have the right amounts. So bad understandings can undermine the rights, but too broad understandings can also frustrate others' free exercise of their rights. So one needs a normative framework to talk about the property and the remedy and to get the two aligned with each other, and I'm going to use labor theory here. So as I understand labor theory, and we'll assume it here, labor means intelligent activity that facilitates the survival of the flourishing of somebody in the community. And property rights emerge because people have rights to labor on resources. And labor understood as an intelligent use of a resource becomes a use-based interest. So use claims justify having property, but use claims limit property as well. You can't claim property on a labor ground for a resource that you're not making any use of for your own benefit or anyone else's benefit. And similar, when you claim an interest to use a resource, you can use it to the extent that your use claims are compatible with others' interests in using similar resources for their own life benefits. So here I'm going to I'll probably go through this slide kind of quickly, but there's that understanding of labor leaves out some or has a tendency to exclude some other possible understandings of labor that can be kind of caricatured or kind of extreme. So labor isn't any mere effort, and the Feist copyright case made a mistake suggesting that labor is any old sweat of the brow. So if you reinvent the wheel and it takes you 2 days to do that, that's 2 days of wasted effort. It's not labor if the wheel's already known and you've discovered something that everybody already knew about. And labor doesn't create a permanent, perpetual entitlement to that which labored on. So Richard Epstein has used a great article to analyze parking spaces and snow dibs. And in a labor-based framework, if you dig out a parking space in Chicago, you can keep that parking space for the entire time there's a blizzard, and the authorities can't dig out the area. But you don't get a labor-based right to keep that forever. There's a good labor-based case to be made. You keep that as long as the city authorities can't plow that sidewalk, but no longer. And similarly, labor doesn't entitle somebody to all the monetary value related with a resource. And a good example here would be a baseball team. Let's say there's baseball games on its baseball field. It has a right to control access to the field and a right to control any copyright associated with televised broadcasts of the field. But if there's a neighbor next door who's using a telescope to watch the game, the right if there's any economic benefit to that neighbor, the ownership of the field doesn't, and any labor justification for that don't entitle the baseball team to shut down the viewing next door. So why have private property on a labor-based framework? Labor rights generate moral interest that people have in using resources as usufructs. Everybody gets equal access to use all, to have some share of resources available to him or her in a community. But exclusive private property, legal private property that creates strong rights to exclude, indirectly facilitates people having these use interests. And the good analogy to think of is a dorm room fridge. If everybody has equal access to the dorm room fridge and no one person has control over it, the fridge gets neglected, all the food gets taken, it gets moldy and all that stuff. If one person's a steward of it and has better control, the fridge will be better kept, and then other people in the dorm might have better access to better food. So different resources lend themselves to different property rights. And in real property, the classic example or the classic difference between rights in water tend to be much more contextual and focused, where rights to land are much more exclusive. And this case that you indirect broad interest in control and exclusion works really well for land and for chattels. And so the broad control and exclusion generate broad zones of managerial discretion, or broad zones of discretion to determine how a thing should be used. And so many rights of exclusion allow owners to veto other people's individualized uses of land or chattels, and those indirectly facilitate the owners engaging in some long-run plan of investment or some complicated commercial activity involving lots of different prospective tenants in one building. Now, remedy laws reinforce and vindicate those property rights. And you can think of this not starting with remedy principles for property, but remedy principles for people. If you had a remedy regime where if one person groped another and said, okay, I'm willing to pay whatever damages there were, there's something that's not quite satisfying. There's something about the person's autonomous bodily interest that's not been respected by a grope every time you pay kind of principle. Property rights create harder problems, but they still start from a similar starting point. Ordinarily, unconsented takings disrupt use, and ordinarily then you start with the presumption that if there's an ongoing taking of property, there ought to be an injunction, but you relax that presumption if the person who's the victim of the property taken isn't using the resources actively in any sense, or if there's some case where there's a collision of two people's property in an excusable accident and the defendant taker seems to have extenuating circumstance. So I think the same principles apply to labor-based patent and copyright. They're different in important respects, as Stan Leibowitz suggested in the last session, but they still confer exclusive control in important respects. And giving patent holders and copyright holders rights to injunctions protect their managerial discretion. So patents give inventors exclusive use of their inventions, and copyright gives authors exclusive use over the power to copy their works of authorship. And exclusive use then comes to mean broad discretion to how to deploy the intellectual work in the manner most advantageous for its limited term. And part of this exclusive use then is the discretion to decide whether to sell it, whether not to sell it, whether to license it, on what terms to license it, and so on. And so that confirms that there ought to be a starting presumption in equity that when a patentee or a copyright holder loses some control over the use of the invention or the copying of the work of authorship, that's an invasion of right. It's a big invasion, and money damages won't adequately repair it. And the way this is expressed in remedy doctrines is to say you presume that the plaintiff suffers irreparable harm, the plaintiff lacks an adequate remedy by monetary damages, and maybe most important, it's hard to quantify the hardships when there's lost use because somebody's making unconsented use by doing a license without getting the license in advance. But you create some presumption that the plaintiff's suffering a big hardship here, and you need a real showing going the other way to override that presumption. But there are two then more specific takeaways, and one has to do with non-practicing entities. Ordinarily, if you think of if a non-practicing entity means somebody who's not making a thing but is rather licensing with somebody else to make the thing in a licensing arrangement that's mutually beneficial, there ought to be no moral difference between the physical producer and the licensor. An IP holder uses or labors on IP by producing tangible goods with it, but it's also use or labor to share it with a producer for joint commercial advantage. And law shouldn't play favorites, or equity shouldn't play favorites between the manufacturing labor and the licensing labor. And then last, The holdout situation, it's a hard case. There can be holdout problems. If injunctions are given in cases where they're not totally warranted, one patentee's use of the patent or insisting on protecting the patent by injunction can restrain legitimate research activity by non-patentees or competitors. But holdout tests, when they work with injunctions, when they work with hardships, holdout tests have to do two things. One is that when they're balancing hardships, the holdout the test for injunctions have to again remember that there's a major hardship, or there needs to be a presumption that there's a significant hardship to the inventor or the IP holder from the lost opportunity to make some commercial or other use of the resource. And the other thing that needs to be taken care of is that the law has to be careful not to turn a blind eye to situations in which people who aren't right holders are being careless or trying to turn a blind eye to whether or not they're encroaching on the patents or the copyrights of others. Now, these kinds of issues about how much harm, the hardship the defendant has to suffer, how careless, reckless, turn a blind eye the defendant has to be, these kinds of considerations are hard to reduce to doctrine or to workable formulas, but in a labor-based framework can't really help in the real weeds of doctrine here. But they can identify the basic concerns. And in doing so, I hope they show that there's a common moral case that the rights for patentees and the rights for copyright holders are similar, and they ought to be treated similarly. Thanks.
Thanks, Eric. Now we'll hear from Mark Schultz.
Well, thanks to Adam and Matt for allowing me on stage. My talk will look at how intellectual property rights generally, and intellectual property specifically, foster individual liberty and political freedom. Now, the common discussion, as Chris alluded to, the common way of framing these issues is that intellectual property serves an important economic function, and that it interferes with or must be balanced with other people's liberties, the liberties of other people to speak, the liberties of follow-on researchers. And what I think this point of view fails to account for is the ways in which intellectual property supports liberty. So the economic argument is important, but it's a narrow justification. And I think we can build on that economic justification. Indeed, a lot of what I say builds on it to understand how the economic rights that copyrights and patents secure further other rights, individual liberties and political freedom. Let's start first with a definition of property that's a bit more expansive than one economist might use. See, property itself is a domain of freedom. A domain of freedom to do what? Freedom to choose. Freedom to choose how to use an asset to meet the owner's needs, how to fulfill their own plans, to secure their needs and desires from mere survival to flourishing. In other words, property right gives the owner a domain of choice, a domain of freedom to choose. It's not unconstrained freedom. It's constrained by the liberties of others. It's constrained by how the property rights define. But ultimately, it's an important set of freedoms to choose an important set of choices are open to the owner to choose how to order their own affairs, to make a living and to thrive. Now, I'm going to look at three ways in which property supports liberty and in freedom, in political freedom. And I'll give some common examples, more familiar examples from property rights, rights in real estate, rights in stock and company ownership, and then expand those arguments to copyrights and patents. Okay, first, property and intellectual property fosters economic independence. These institutions also enable a private sector, and finally, they support political freedom. Now, in terms of how property fosters economic independence, I think our common understanding of this would be conveyed by the insecurity of a traditional company town, where, say, a worker lives in housing supplied by their employer, versus the security supplied by homeownership. But economic independence is more than that. The property rights afford even a greater realm of choice and security for people to order their affairs as they see fit. Businesses choose to pursue a vision of the good based on their ownership of stock and physical assets. They come to very different arrangements. They choose to do very different things. And their economic independence is what allows them to do this, unconstrained by others' demands and conscience. Indeed, a company like Apple, and Steve Jobs' work with Apple is perhaps particularly famous for this sort of stubborn pursuit of a vision. Steve Jobs brought us products that we didn't know we needed yet. He drove his people to create products that he envisioned. Through his singular vision, he pushed people to create, and he could do that because Apple had a certain degree of economic independence conveyed by property ownership. Now, when we consider the realm of intellectual property, this kind of stubborn independence that property rights afford is particularly important. Consider that creators and innovators are often disruptive forces. They're often doubted. People doubt that they can do what they say they're going to do, at least until they do it. Then after they do it, everyone wants to steal it. But before they do it, it's often in doubt. Consider that one of the standards for patentability is non-obviousness, that you are doing something in a way that people often doubt that doubt can be achieved. Let's look at a couple of examples. Consider Irwin Jacobs. Irwin Jacobs founded Qualcomm. He created the CDMA technology that is the basis for how these wonderful devices, our smartphones, communicate. When Irwin Jacobs invented CDMA, and his team invented CDMA, there were doubters. A Stanford physicist declared that the CDMA standard defied the law of physics. As late as 1996, the Wall Street Journal fretted that Jacobs' overhyped invention was holding back the U.S. communications industry. Now, luckily for Irwin Jacobs, he didn't have to satisfy a panel of Stanford scientists or skeptical journalists or experts to get funding. He didn't have to get permission from a government board to pursue his innovation. He had to convince investors and customers, but that is a much easier job to do, provided you have a property right that secures a potential return on that investment. This economic independence fosters a certain stubborn creativity. From the creative world, consider James Cameron, one of the most commercially successful filmmakers in recent years. Before each of his big movies in recent years, Titanic and Avatar, at the time each was the biggest budget movie in history, there was a tremendous amount of doubt and no small amount of schadenfreude. Oh boy, this is going to be a disaster, and people couldn't wait. Titanic, the connections were obvious. They were just waiting to make the puns. And yet Titanic proved, as we know, greatly successful. Similarly with Avatar, they thought, well, this time people were saying, Cameron's gone insane. He spent hundreds of millions of dollars of studio and investor money and his own money, not just making a movie, but inventing the technology to make this movie. If Cameron had to go before a board of bureaucrats, like a French filmmaker, to obtain financing for his film, I doubt these cautious souls would have ever financed his ventures. But once again, James Cameron had a degree of economic independence fostered by his copyrights and the potential for return on them to pursue his own vision. So economic independence the economic independence supplied by copyrights and patents is an important source of individual liberty. Now, property also creates a private sector. And for many of us, this just creates a place where we can do what we want free from the interference of others. But the private sector functions of property are more important than just being left alone. Sometimes people use their property to pursue their own unique visions of the good as to what they should and could be doing on their property. It goes beyond that, though, that function. It also, besides being left alone, besides doing what you want on your property, it also enables cooperation. There's this domain of freedom in which people choose to order their affairs as they see fit. For example, to worship or to form particular types of companies. Intellectual property creates these private sectors, these zones where people cooperate and achieve very different visions of how they should organize themselves, what the good is. Consider companies as disparate as IBM, Microsoft, and Apple. They all own intellectual property. They use it in different ways. IBM pursues a mixture of aggressive patent licensing as well as support of open source software. Microsoft is known for one model of software development that's a much more open platform versus Apple, which is known for its more closed platform. These different visions are all enabled. These different forms of cooperation are all enabled by the private sector, the zone of non-interference that copyright creates. Disney, as Troy Dow told us, pursues its own vision as to how its intellectual property should be used, what it wants to achieve with its franchises. It has a long-term vision, and within that vision, within that intellectual property, that zone of non-interference, it creates theme parks, movies, television shows, and pursues down through the years a long-term vision as to how it wants to cooperate with others to license and use its intellectual property. Others have a different vision. Red Hat, for example, an open source software company, uses intellectual property rights. It uses trademarks. It also uses copyright, but within that zone of copyright, it chooses to work on projects in which commercial exploitation of the source code of the copyright in the software itself is excluded. These are all possibilities opened up by having a private sector. Also, people combine their property rights in this private sector to cooperate with very different visions. We have patent pools. People combine into patent pools like MPEG-LA. They bring their intellectual property to these pools and choose to collaborate. ASCAP, similarly, is a collection of property owners, copyright owners, songwriters, who choose to enter into a collective arrangement to collect royalties. Technical standards like the LTE standard represent the combination of many forms of intellectual property. This private sector allows people to pursue these different visions, even to choose to abstain from commercially exploiting their intellectual property in some ways, as in the case of open source software. Sometimes that private sector is a fictional universe. A broke mother named J.K. Rowling invented Harry Potter, wrote those stories. She not only was able to pursue her own vision as to how that story should unfold, but she invited others into her fictional universe to make movies and theme parks as she chose to see fit. She cooperated with others as to how to best exploit her vision of this fictional universe. There's a third way in which intellectual property supports liberty. It fosters political freedom. Now, it fosters political freedom in two ways. First, it disperses power. The more widely property is dispersed through a society, the less likely political power is to concentrate in any one party. We see this in the creative industries. Consider the contrast between, say, at one ridiculous extreme, North Korean state media versus the media we enjoy, where there are low barriers to entry and many property owners create their own content through many different distribution channels and create a diverse message, a diverse marketplace of ideas. As Justice O'Connor said, copyright is the engine of free expression, and this is the world it helps create. Similarly, property disperses power among innovators. There is no one technology company whose voice outweighs others, despite the recent attempts by a certain large search company to spend a lot of money in Washington. It's still only one voice of many. And there are relatively low barriers to entry that allow an Irwin Jacobs with an invention to come to be a new big player on the scene. Now, the other interesting way in which intellectual property supports political freedom is it creates a vested economic interest among certain parties in freedom of expression and freedom of inquiry. You see, you need freedom of expression to exploit your copyright. You need freedom of inquiry to exploit your patent. So you have these players enter the political process. The New York Times, for example, and other media companies have been the biggest defenders of the First Amendment in court and in the political process. In the 1980s, when Congress threatened to censor pop music, you had an unlikely group of creators, Dee Snider, Frank Zappa, and John Denver, coming to the House of Representatives to testify on behalf of their freedom of expression, which also furthered their economic interests. Innovators support freedom of inquiry. There's been a great controversy over stem cell research and genetic research in recent years, for example, and innovators have worked together to participate in the political process to defend their freedom to operate, their freedom of inquiry. So in the end, these functions of property, supporting economic independence, supporting the existence of a private sector, and supporting political freedom, all contribute to the ability of creators and inventors to pursue their own goals, to survive, but not just to survive, but ultimately to thrive, which is one of the reasons intellectual property is a moral institution as well as an economic one. Thank you.
Thank you, Mark. Now we'll hear from Ken Anderson.
Thank you. This is one of those and now for something completely different moments, because unlike the preceding speakers, I'm not a lawyer at all, and I'm certainly not going to try and speak to the law. I'm a technology developer and an entrepreneur. And what I'm going to do today is speak a little bit about the creation of technology and the process that goes into that, using the technology that I've been involved in most recently as an example. One of the very first speakers today spoke about the process of intellectual property coming from problem to solution, and I'm going to go through that whole process today, dealing with how Thermoquatica and SRU have been involved in dealing with a particular problem. And towards the end of that, I'll get to the part where we talk about IP and how IP has come to play in that. Now, this is a technical issue, but I promise I'm going to be quick, and I'm going to keep the geek speak to a minimum. Okay. The stuff in this bottle is really quite extraordinary. Really, life as we know it couldn't exist. But I'm not talking about the water. I'm actually talking about the bottle itself. I would bet a week's wages that everyone in this room has very, very little appreciation of just what is involved in making that little piece of plastic. And I'd also bet a week's wages that you don't realize how close to it you are right now. And I'll address that in a minute. What this material is, in geek, it's called Polyethylene Terephthalate. Even for geeks, that's a mouthful, so we just abbreviate it to PET. And if you recycle plastics, and I hope you all do, this is the number one. If you look somewhere on this bottle, there'll be a little tracing triangle with a 1 in the middle. Very, very important material. To a scientist, it's what's called a polymer. Now, this is where the technical part goes away. Polymers are just chains of molecules. And if you remember kindergarten, when your kindergarten teacher said you want to make a chain, you pick up the block with a hook, and you pick up a block with the eye, you put the hook through the eye, and you made a chain, right? That's what polymers is. There's the end of the chemistry lecture. Okay? A long time ago, scientists worked out how to make two particular materials, one called ethylene glycol, that's antifreeze, and another called terephthalic acid, work together. One's got two hooks, one's got two eyes. They figured out how to put the hooks through the eyes, they made chains, and voila, PET was born. This material, though, it's more than an interesting chemical trick. It is, in fact, an enormous business. Globally, we make somewhere between 30 and 45 million tonnes of this a year. Okay? At $1,000 a tonne, which is an approximate value, you're talking about at least a $40 billion annual gross sales. So this is not just an interesting piece of science. This is an enormous business. Okay? And there's nowhere on earth that you can go to mine this stuff. We have to make every bit of it. It's all about the technology. What very few people realise is that every piece of this plastic bottle started out life as crude oil, pumped out of the ground as a black soupy liquid. Okay? Nice clear bottle, but every bit of it came out of the ground as crude oil to begin with. There's a whole value chain, and I won't go through the details of it, but it starts with crude oil, and then clever engineers go to work on it, and they kick it around for a while, and they kick it down the road a bit, and out comes plastic at the far end of it. Okay. The other thing you need to know about PET is that environmentally it's a disaster, because it doesn't degrade. You can drop PET into the environment and it will stay there for centuries, more or less unchanged. Okay. The last point I want to make about PET is that it has an interesting economic history. Okay. It was actually discovered during the Second World War, and we were kind of busy at the time, so we didn't get too involved with it for a few years. And the first time we introduced it as a commercial product was 1950, when Dow introduced Dacron. The humble plastic bottle that I just introduced was patented in 1973. Throughout that whole period, the price of crude oil was between $1 and $3 a barrel. Even adjusting for inflation, it was between $15 and $20 a barrel in today's dollars. It's not between $15 and $20 a barrel anymore. Okay? And it's not going back to $15 or $20 a barrel anytime ever. Okay? Anytime ever. Never. So the question has to be asked, if we were starting over today, would we pick to make a material like this if we were starting now? And the answer is probably not. The raw material it's made from is too expensive, and the environmental properties are just not there. So for that reason, there's a lot of people, myself included, as you've probably guessed, who are interested in making materials that work like PET, have similar properties to PET in terms of I can make nice clear plastics from them, but which have better environmental performance and are cheaper and are made from cheaper feedstocks. The place to go always, in my opinion, the place to go if you want to find out how to make something is look at how nature made it. Okay? Go there every time, because nature usually gets it right. So if we think this is terephthalate, okay, the T of PET, think of it as a molecule with two hooks. Okay? Plants make material with a hook and an eye. Okay? I'm not going to go through the details. This one I'm just going to abbreviate to PHB because it's too much of a mouthful. This one's vanilla. Have you ever had vanilla ice cream? This is what you're eating. Okay? They're just molecules with a hook and an eye, and you can link them together to make plastics just like PET. You can start with agricultural waste. This is corn stover ground up. This is wood, forest waste, sawdust, and so forth. And this is coal, and coal is just the fossil form of wood anyway. Okay? And with apologies for anyone who's got a chemistry background, you can see the two types of structures are almost identical. Okay? The only real difference is that in terephthalate, the hook's this way and the eye is this way, and it's the reverse in the alternative polymer, which is called polyethylene vanillate, another mouthful, so we just abbreviate to PEV. Properties, ignore all the geek speak on here. The properties of PEV and PET are so similar that it really doesn't matter. They overlap completely. The melting point, the viscosity at temperature, and all the other things that polymer chemists and polymer engineers worry about, they overlap almost identically. What is different between these two materials is that PET won't degrade in the environment, PEV will. Okay? Ordinary fungus, ordinary mold, things will go after it in time, break it down, just the same way they break down plant matter, because it is ultimately derived from the same building blocks that make up large parts of plants. So here's the problem. The price and availability of the raw materials that are used to make PET are in question. Petroleum's gotten more expensive and is going to continue to get more expensive, and it's going to be volatile for a long time. Alternatives like vanillate are very, very expensive, and they're not available in commercial quantities. So we can't make alternatives to PET right now because we don't have commercial quantities of the raw material at reasonable prices. That's where Thermoquatica came into the game. Now, Thermoquatica is a spin-off that started out of SIU. I started it in 2010. And we developed a process called Oxidative Hydrothermal Dissolution, another big mouthful. OHD is a very simple process. It uses water and oxygen, exactly the same ingredients that go into breaking down materials in the environment. If you've ever gone out and walked in a forest or even have a compost pile in your backyard, every time it rains you get this little tea-coloured liquid coming out the bottom of it. That's just water and oxygen breaking down the raw materials. OHD is an incredibly, stupidly simple process. Someone once asked me, do you feel clever for having invented this process? It's like, no, because there's nothing clever about it. It's absurdly simple. All you do is take your product, grind it up, okay, mix it with water, okay, heat it up, get it at the right pressure and temperature, mix in oxygen at the right temperature and pressure, allow them to come into contact for about 10 or 15 seconds, and it dissolves. I wish I could tell you that there was some, brilliant feat of intellectual genius there. There's not. It's just about bringing everything together in the right way, in the right ratios. It's very simple. It's inherently environmentally friendly. Doesn't have a greenhouse gas footprint because we produce almost no CO2. We don't produce any NOx or SOx, the kind of things that plague traditional uses of things like coal. We don't have any of that. We don't need any exotic solvents or expensive catalysts. There's no magic foo-foo dust involved in any of this. And we can get a very effective route to high volume, low cost production of vanillate and the other materials that we can use to make the plastic water bottles that we all want. We've done this at the lab scale. We've done this at the small engineering scale. I have to show this because my engineers would shoot me if I didn't show you a picture of their famous toy. Okay. And my engineer insists I include him in the picture as well. This is what it looks like. This started out as coal. That's coal dissolved in water. Okay. Okay. And if we spill the stuff, it's not going to be like Deepwater Horizon, because in fact it's so biologically active that it goes moldy if we leave it lying around the lab. So the kind of gross picture at the top there is what happens if you leave this stuff sitting around over the weekend. So, all this is our IP. This is where we are at now. And it's been a long and very expensive road to get to where we're at. The original idea underpinning OHD started in 2004. Okay? We spent the next 4 or 5 years trying to prove it and then disprove it. We first tested the idea to see if it would work. Then we spent a long time trying to break it, to see what its fatal flaw was, to see why it wouldn't work, where it would die. I'm an academic. I chose to go into academia because I'm not necessarily naturally leaning towards business. I had to be trained to become an entrepreneur. So I went through entrepreneurship training. Finally, in 2010, Thermaquatica was founded with one asset, our IP, and sweat. That was it. We had zero cash on hand. Okay. We obtained a small grant and started operations in 2011. We had filed a round of patents, and by we I mean the university filed the first round of patents in 2009. We filed a second round of patents in 2012. We completed our engineering scale work in 2013, and shortly thereafter that we managed to attract a multi-million-dollar agreement with an Australian energy company called Green Power to build a multi-ton per day demonstration scale facility. So we've taken it in the space of 10 years from a lab scale idea, that literally the first reactor was about that big, to now we're working towards build our first 20-ton a day plant, and after that the next scale up will probably be of the order of 500 or 1,000 tons a day. Our first round of IP protection was filed by the university, by SIU, in 2009, and those patents are now issuing. They've issued in the US, in Australia, in Russia, in South Africa. They're still pending in about, I think it's 11 other jurisdictions, 12 other jurisdictions. And we have filed a second round of patents in 2012 in over 30 jurisdictions around the world. That's how IP is produced. It's not just a creative spark. Okay? There is that, but there's a hell of a lot of sweat, tears, and money that goes into getting it from that first creative spark up to something that's ready for commercial deployment. I'll wrap up within my time. IP is all about giving credit where it's due, so I'm going to acknowledge a few people before I walk away from the stage. First of all, I am the primary inventor of OHD and the founder of Thermaquatica, but I haven't worked alone at all. I've got lots of colleagues that I've worked with, current and former students. Some of the colleagues that I work with, we've had support from the state of Illinois, we've had support from the university, we've had worked very closely with folks at Green Power, and they all deserve credit for helping get this concept to where it is today. And with that, I thank you all for your attention and hope that this served as an example that will give you an idea of what the other side of IP is about, not the protecting of it, but the creation of it, and hopefully that will be useful for you. Thank you very much.
Thank you, Ken. David.
Hey, thanks for inviting me. My name is David Lowry. I'm an instructor at Terry College of Business. I'm probably better known as a performer with my bands Cracker and Camper Van Beethoven. I had a different talk prepared for this, and I wasn't going to use slides, but yesterday I spoke at what's called Brooklyn Beta, which is a conference of basically web developers and web designers, right? These are people that usually do not want to hear anything about copyright. In that world, copyright has a bad name, right? To a certain extent. I mean, not totally, but this is a really crazy sort of conference for me to speak at. And as I was talking to my son, when I was telling him where I was going for the weekend, he's 15. I think he was born wearing an ironic, sarcastic onesie, okay? It's the way we talk. He appreciates the world very, very much, his way of dealing with it, but he asked me where I was going, and I explained to him, he goes, oh, so are you going to break the internet then, right? So we laugh about this for a little while. But really, I mean, that was a really strange place for me to go and start talking about copyright. Because I'm very critical of sort of the digital infrastructure that we have for distributing music or content, as it's called in that world, which in of itself is offensive, the use of that name in a way. But in my 25-minute talk or something like that, I got to the end, I got a standing ovation from these kids, okay? And partly because I realized that this little slideshow that I showed them is all about just ethics and morality, right? I didn't even really talk about music through most of this, right? So the first thing that we have to understand is I had to make them understand that I was one of them, right? That we're all the same. We all have the same shared ethic and moral sort of values or whatever. So I showed them that I have a degree in math from UC Santa Cruz, Go Slugs, that's our mascot, it's very famous. I was very much a part of making that the mascot. Because the university, that was our unofficial mascot. The university wanted a sports team. They gave us the seals. So if you tell a bunch of students that they can't have their old mascot, well, we end up getting it. I showed them I was a computer programmer. I showed them I worked at this farm, actually, as a computer programmer, which is very strange. And I told them that I was an amateur radio geek, and I still have basically, we amateur radio operators are sort of a form of part of the civil defense network of the United States. In the case of emergency, we basically can kind of put a sort of standalone internet on the air circa about 1996, okay? It's not very fast, doesn't do very much, but it works with no infrastructure whatsoever. So, we talked about the music business back in the 1950s, how bad it was, you know, or the stories that you hear about it. Here is T-Bone Walker, I think is his name, on the left, and here's a 56 Cadillac. And what would happen a lot of times is the artists would make, you know, have a hit record, and they'd come to the, you know, drive up to Memphis from somewhere in Mississippi, drive up there and say, hey, where's the money? And it's like, well, you know, we're giving you a lot of promotion, you know, we're making you famous, right? And here's a Cadillac. And of course, those two things were never really worth quite what the contract should have, you know, said they were due, or maybe it was. We don't really know, right? But generally, the artists tended to get underpaid, and everybody kind of agreed that the 1950s music business was rather exploitative of artists. So regardless of copyright or anything like that, there's sort of a moral sense of wrong here, right? And I used to think that was an urban myth until I found out that my mother-in-law worked at Sun Records. My father-in-law sold Fords, and that's how they met. She'd run over and buy the cars from Frank for the artists. True story. So what we have right now is file sharing, you know, the probably about 60 to 70% of the music business, digital distribution at least, but let's just say 60 to 7% of the files going around. It's like the 1950s music business, which we all morally agreed was wrong, except you don't get promotion and you don't get the Cadillac, okay? So relatively, we can all see that this is wrong, right? I also spoke to them a little bit about this, that this is kind of unfair. You know, the old boss, my original talk was called Meet the New Boss Worse Than the Old Boss. And that, you know, as much as artists complain about record labels, they put up 100% of the capital risk. When you start talking to developers and web designers about, oh, the capital, oh, the venture capitalists, so wait a minute, yeah, capital is good, right? You know, and then the new boss, winner take all. You have this kind of built this winner take all system, and the companies that really profit the most from it, there's no real capital risk in creating the content, right? So, you know, even these sort of, as I call them, free haddis sort of web developers, they get this, that that's not right. Also, was this a deliberate plan to screw artists? No, of course not. And as my Silicon Valley lawyer friend said, neither the music business nor technology business is farsighted enough to pull this off. which I thought was really funny. I also am famous for writing this letter, which got read about 10 million times. It was a letter to somebody who worked at NPR. And I asked this question: why do we pay for the pipes, which are the corporations and the man? Why do we pay for the hardware, which is the corporations and the man? And why do we don't pay the hippie freak musicians? So this is a huge cultural change, right? Get the hell out of Vietnam to we demand free stuff, down with hippies, and hooray Lockheed, okay? Everybody understands that's not right. That's not right. So, by the way, I should say, has anybody watched the show Silicon Valley? Anybody seen it? Okay, most of this is the wrong audience. When I asked that, I didn't have to ask that in that room. And one of the reasons I made them feel like I was them, one of the ways I did that was I walked out wearing an Aviato shirt. It's one of the fake companies on Silicon Valley, and the guy that started that company always says, when I sold Aviato to Frontier Airlines, right? So that was the first thing I said to them. Of course, that in itself almost got a standing ovation, right? But we talked about this. We talked about the old web, right? I loved the web when it first came out. It was a great, and it still is, a great liberating experience for artists, right? And it was symbolized by funky homemade band pages, and I called it the triumph of the band, right? There's all kinds of interesting variation. Our fears then were monopoly. But then we went to this process of re-intermediation, Web 2.0, Facebook band pages, and the triumph of the platform. And the triumph of the platform was enabled by this loosey-goosey sharing and essentially destruction of our intellectual property rights as content creators, right? The platform triumphed, right? Bounded variation, and our problems with that are monopsony, okay? So I asked these kids, first of all, what's Web 3.0? What's the third decade of the web look like, right? And I couldn't think of a name for it. Well, we went through all these different ones. I finally decided that Happy Flower Land made as much sense as all these others, okay? So here are some of the rules I gave them for Web 3.0, how we can make it a better place, and these are all moral. Ubiquity means nothing. Just because my stuff is everywhere, it doesn't help me, right? Being able to control where my stuff is helps me design a real business model. It also helps those that are innovating, building the platforms, right, who are building streaming services to figure out the new ways that we're going to have to monetize music in this technological age. It limits them too, right? I described it, I had Spotify programmers, RDIO programmers in front of me. And I said, basically what you guys are competing over, because everybody has to be on both of these platforms, all the same songs have to be on both of these platforms, you guys are basically in an arms race to design the best buttons, right? Ubiquity, like, limits all kinds of innovation, right? And I also pointed out that Apple, with a tyranny of choice too, if you have a tyranny of choice, being everywhere doesn't matter. I mean, when there were 15,000 albums a year being widely distributed and in physical stores and limited shelf space, that mattered. But with 150,000 or whatever albums that come out every year, actually I think it's more like 80,000 albums that come out a year, being everywhere doesn't help you, right? And I pointed out that Apple, with a very low market share, was much, much more profitable than Dell. So it doesn't even make sense on an economic point of view, from an economic point of view, sorry. Okay, but this is when I burned the house down, okay? I can't figure out, I really would love to attribute this to the person, but it was on a web form and I couldn't figure out if it was really there, so I didn't attribute this quote to this person, but it's a very, I don't know, I guess a well-regarded thinker in Silicon Valley purportedly said this. So warning, this could be a straw man argument. I can't prove that he said this. This was just posted on a web forum, and somebody else said that this person said this, but this is an amazing quote, and it does illustrate what Silicon Valley and those who demand the weakening of property rights, intellectual property rights, often say things like this. And what this guy says is, the history of the 20th century makes it clear time and time again that new media businesses are built by tricky lawyers, helping their clients to plant a business in the, how do you say that, lacunae, like a backwater, right? Is that what it is? Gaps, okay, sorry. Lacunae and DMZs of copyright law. Broadcast radio, cable TV, jukeboxes, VCRs, MP3 players are just some examples. In many of those cases, the legal rationales were far more outlandish than the DMCA rationales being invoked by the Web 2.0 companies. In several cases, the lawyers lost the battle, but the businesses won anyway, right? I'd like to quote the Big Lebowski now, or paraphrase the Big Lebowski. It's not that you're wrong, Walter, it's just that you're an asshole. Really? We want to reward tricky lawyers instead of, like, successful businesses, innovative businesses are built on the works of creators, inventors, designers, artists, programmers, coders, and all of that, not tricky lawyers, right? Thank you.
Thank you, David. So we have some time for discussion. I thought I would start by checking to see whether anybody who's on the panel wanted to make a follow-up comment on something that somebody else said. If that is not the case, then we'll look out to the audience for questions. Anybody? We have people with microphones, correct? Over there.
I've heard that one possible future of Web 3.0 involves micropayments, so that you can just pay for every web page you look at, a small amount, or any service you want, and pay the artist directly too. What are the prospects of that?
We already have a system like that. It's called the banner advertising network. It's super sophisticated with exchanges. Is this on?
Yeah.
Yeah. It's like exchanges, and we basically have micro payments, floating all around the world. It's also probably a really excellent way to launder money. The problem with it is that the intermediaries have captured all the value, right? I mean, Spotify's business model, for instance, which is the legitimate streaming services, relies on advertising, but so do the pirate sites. So yes, that's a solution in a way, but the problem is if you have total market failure, if you're like we songwriters who've been completely abandoned by the Department of Justice, performers, there's no way for us to ask those people to pay us, right? I mean, there's a point, there's something very good in what you're saying, but I just also point out there's a lot of other things. There's a market failure problem that has to be solved first.
I just wanted to say that, Ken, I really appreciated your explanation of the amount of work it takes to actually apply and get a patent, and all that happens before that, and the amount of time it takes. And because I think a lot of people generally don't realize that there's a ton of time that it takes and a lot of money and a lot of work that goes into doing these things, even to patent what you say is something that was a very simple idea. It's very important. David, I loved your take on the music industry. I'm a musician myself. I actually own a small record label. And the one thing about the dilemma, I think, that we're having. And it's great that people really feel so strong about music. If you think about the music industry, it's a very small part of the economy, but people seem to be very passionate about it, which is great. I think what happened with Napster and all that is that technology moved a lot faster than the law, and it became more convenient for people to start sharing music, and it became not a bunch of people who wanted to quote unquote screw the songwriter. It just became too damn easy to do it. Now we're just kind of playing catch up on it, and it's hard to figure out ways for that. One of the things that I feel very strongly about is crowdfunding. I think that getting artists paid before the actual music is released is a pretty viable solution. What is your opinion on that?
Well, it works if you're an established artist already, if you already have some sort of following. I mean, you don't have to be like worldwide famous, but I see it work with crowdfunding. I see it work very well if, like, for instance, you're somebody like Sons of Bill from Charlottesville, where you have kind of a regional following, Virginia and North Carolina. You can crowdfund very efficiently. What it doesn't do is discover those wild, mad geniuses, the Brian Joneses and stuff like that, who can never get it together to crowdfund or to self-promote themselves or all of that stuff. And so I think we'll be a poorer society culturally if we go to crowdfunding. It also allows those with more money and resources to decide who is going to make albums. So, I mean, if you're fine with George Soros or the Koch brothers or whatever, you know, or governments telling you which artists get funded, then that's a good idea. I know crowdfunding is a little more democratic, but only marginally. And just as far as going back to your point that, you know, technology got ahead of the, you know, essentially our morality, I would argue that technology got ahead of our morality, and then corporate interests figured out they could make a lot of money from the ad-supported piracy ecosystem, data mining and doing all of this, and blocked us from having our laws catch up with the technology. And principles are what guide us through times of technological change. We don't change principles to match the technology. I mean, we're the master of our own worlds, and our own societies. The machines are not.
I'd also like to make a point about that as well. There's a really common narrative that technology got ahead of the law. And I think it plays on a common human instinct that the way things are now are the way that they had to be inevitably. And that's not always the case. Sure, our environment's a product of technology, but it's a product of legal and institutional choices we made in the late 90s. And I think it's a failure of imagination to say that things inevitably had to be the way they ended up. We treated the internet like an infant industry, and that's great. And there was a certain techno-libertarianism that a lot of us cheered on at the time. I still have an old mouse pad that says, you know, keep government regulation off the internet. It's a tie-dye mouse pad. And, you know, back in the old John Perry Barlow days when that seemed like such a liberating move. But what it did is it took away freedom to choose from property owners, from copyright owners. And we could have had a different environment. We could have been more respectful. We could have written the DMCA to respect the rights of creators more. We could have demanded more from people participating in this under the same tort principles we've always had in this country and other endeavors off of the internet. But we chose to do things a certain way, and that's how we got to where we are. It wasn't inevitable. There were choices made, and some of those choices, I think, were had unintended consequences that have been tremendously destructive of the creative industries and other industries, as well as generative, yes, of some great technological process, but things didn't have to be this way.
Yes, thank you. David, that quote has been around, and I'm just wondering why, thanks to the magic of the guy's employer today, you can find it in various places. So I'm just wondering why you don't attribute it.
I just, in the 12, well, you can say who it is, but I didn't want to say who
Fred
it
von
is.
Lohman.
Yeah, okay. I just couldn't confirm it anywhere, so I didn't.
Well,
Okay,
I've seen like with his permission, blah 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 blah.
okay.
So
Yeah.
It's
I also
Fred.
don't go, the conference I went to yesterday, we had no internet there, which was awesome.
talk about irony.
Yeah, we were not even supposed to have our phones in there, which was incredible. So, yes.
How do you think the courts are doing with the common moral case for copyrights and patents? There was a ray of sunshine with Justice Breyer's decision in Aereo, where the tricky lawyers actually lost.
Mhm.
But what is the trend line? Mark, you mentioned the DMCA. The DMCA hasn't fared too well in terms of judicial decisions. They're all over the place.
Yeah, I suppose I'd say it's disappointing. The courts generally take the utilitarian view, a pretty strict utilitarian view where copyrights and patents are the cheese we hold in front of the poor creator or inventor who runs on the wheel to give society more stuff. And when you take that point of view, it's often it often results in the skeptical decision we're seeing. Even Aereo, you have to wonder. Some speculate it was a product of Justice Breyer trying to limit the damage as he saw it, rather than have a broader decision. But it's a mixed bag. And I think some things don't stand. Some things just reek too much, like Grokster and Aereo, to let people get away with them. But on the whole, courts. I don't think the courts have done such a great job.
Well, I mean, considering Kim.com is still like living in a mansion somewhere and stuff like that, I mean, really, we need to talk about the commercial enablers, the payment processors. We need to get we need to get re-familiar with RICO. You know, I mean, it's a mass copyright infringement, and enabling it is a RICO predicate. I'm very disappointed. I think we've had the entire, largely had large swaths of the government basically corrupted and captured, agency captured, by the technology industry. And we're going to it may not feel bad yet, but we're going to really feel that over the next 10 years.
I want to say a little bit. I can't say a lot just because I know a few IP cases. I don't claim to know the gamut of all the most recent cases. But the ones that I'd read, I guess I'd say this, that first, I'm not sure that I find labor theory and rights-based theories more satisfying ultimately than utilitarian cases, but on these kinds of issues, I'm not sure. I mean, maybe the labor-based theory gives a slightly stronger count, but not that much more of one. And one can come up with strong utilitarian cases for IP. And so to me, the questions to ask aren't whether the courts get the moral case or not, it's whether they get cases for property or not. And I mean, I'm fascinated by the eBay case because there's a couple of tendencies in that case. So one is that the majority, the court opinion is very timid about saying anything in a general way about the relationship between the right of the patentee and the remedy. It's trying to say the absolute bare minimum that whatever needs to be done consistent with the way these background equitable factors all apply in lots of other fields. With that, and with the court was the court opinion was very timid about saying these general equitable factors apply in different regular ways in different substantive areas like property, like EIP. That didn't even go there, and that shows a discomfort with property, and that's troubling. And then the other thing that's noteworthy is that Kennedy's concurrence is saying things about NPEs are the kind of things that you read in newspapers, and you read in newspapers because you know that there are certain companies that have educated reporters to tell certain kinds of stories, and that makes a difference, and that gets to the judges. And that's the judges are being unknowing carriers, or things that are being shaped in the culture by companies that are having these fights in committees, but also in PR. And so that's all a long way of saying, I'm not sure the most important thing is whether labor is grounded on a moral case or a utilitarian case. It's the people that are sympathetic to having a robust property regime and understanding that justifies property within sensible limits have to do work educating legislators, and do work educating judges, and do work educating lobbyists, and do work educating people who write in the press. And there's always a back and forth between people who want minimal property and strong property.
But David, when you were saying the DOJ has abandoned us, isn't the culprit Congress?
Well, no, I mean, I think it's, I think it's really clear that there's organized groups that, and companies and such, that are massively infringing copyright. There are companies that have red flag knowledge that there's... Well, because the DOJ looks out for little people like me, because I'm not a $398 billion corporation. You know, it's me against the $398 billion corporation. What would happen if I have a friend down in Florida who did try to sue one of these companies?
The criminal aspect of copyright that you're looking for,
Yes.
you don't have any patents. Where
Yes.
you have private cause of action. Is that the reason so
Yeah,
we have
exactly.
enforcement through criminal, but
Well,
you still have a private right on the civil side.
yes, and if you do that, your case will get moved. You say, like my friend who was down in Florida who had a small label, decided to sue Google for, search, that was turning up his files, and, what happens to him? The case is, he even just wrote a letter saying he was, thinking, I don't know how this stuff works. Basically, in his letter, he threatened somehow that he was going to sue this company. Suddenly, he's in court in California. He lives in Florida. You have, gold-plated law firms, and you're a guy with an indie blues label in Florida, you're going to fight Google? I mean, really? I mean, that's why we have a government, is so that the strong don't prey on the weak. That's why we have a civilization, So I think the civil remedies when it comes to the rights of individuals is, it's really hard for us to take civil remedies. Who's going to take that case? Who would take that case? Who would, and what politician would stand up for you in an election year?
So I was hoping that you could comment, and this is kind of for probably Mark most of all, and possibly Eric and David, about the role of rhetoric and red herrings in this debate that deflects attention away from the moral rights of authors and creators. Some red herrings and some rhetoric that comes to mind is the whole patent troll discussion on the patent side, and on the copyright side, I think about slogans like "Don't break the internet," and how these kind of powerful memes have taken away so much attention from these moral rights.
I don't want to answer every question,
you've been
but
at the sharp end of that. So
yeah,
you can
my
start.
son, knows enough to make a joke about the break the internet thing. First of all, some of the things that were supposed to break the internet in the SOPA bill were actually enacted in the UK, and as I was over there, their internet seemed to be working just fine. It didn't seem to be broken. Secondly, I think it's really a misnomer to talk about the internet, and some people are, somebody I saw was recently sort of blasted for talking about the internet as being a collection of sort of cables and computers and stuff like that. Well, I'm sorry, it actually is. The internet is not a place. It's not a thing. It's a sort of loose interlocking collection of like computer protocols, network switching devices, fiber optic cables, 4G wireless networks. I mean, it's this just big mess of thing. Most of it doesn't ever actually even talk to each other. And we call it the internet because it imbues it with this like power. I mean, you've heard of the singularity, right? There's people who actually think that the internet is this being that is just waiting to become sentient, right? I mean, just talking about it in this way, just even talking about the internet as if it's a place, rather than what it really is damaging, and it just doesn't. We just can't even have a debate about it when you talk about it as a place. So that was actually one of the things I did at that conference, which got much applause. As I said, you know, Web 3.0, there is no internet. We will no longer discuss the internet. There is no internet, right? You know, we'll never say we're on the internet, or we're never going to say. You're going to say, I'm using WhatsApp on my own iPhone to talk to my friend, right? You know. Sorry, I got off topic.
So I think Matthew's question's a good one, and part of the situation I think starts with always with both opponents and proponents of intellectual property framing it in terms of purely economic case, which is essential. It's necessary but not sufficient, because what you often hear is IP creates jobs. And you can make a great case for the IP-intensive industries, foster a lot of jobs, and they secure investments. But then people turn around and say, yeah, but it stifles freedom of expression. It stifles innovation. There was this guy out there who got a cease and desist letter. You know, Ed Felton, a researcher at Princeton, was doing research, and he got a cease and desist letter. I wish that cease and desist letter had never been sent to Ed Felton. He's been dining off that for years, and it's a favorite anecdote of copyright skeptics. But this argument by anecdote, where people's moral interests are opposed to economic interests, it's very difficult. And even in international relations, it's the rights of pharmaceutical companies to make a profit versus access to medicine. People are dying. We're told. People need access to knowledge. Publishers need to step aside and let people in poor countries get access to knowledge. See, when the debate's framed purely in terms of profits versus morality, and I think profits are moral, but purely in terms of jobs and profits versus morality, it opens up the opportunity for people to create these memes. You know, the evil patent troll, the big pharmaceutical company that puts profits before people. And it's always going to be a tough sell, but they've even managed to make people like David into big copyright. You know, the big shot rock star who's sipping champagne out of crystal glasses, who doesn't need the money. That's the story we hear, and so I think the proponents, the supporters of the creative industries and the innovation industries need to make the moral case as well as the economic case, or this kind of rhetorical slamming will continue.
I agree with most of Mark said. I want to put it a little bit differently. I guess the question you asked kind of suggests there's something abnormal or wrong about people using these memes and rhetoric. To me, I love Federalist 10, and one of the Federalist 10's key insights is that everybody's passion and the reason are commingled about their own things. That's just a fact of life. It's inevitable that this is going to happen. And so then the question becomes, is somebody who cares about robust property going to argue back by saying it's wrong of you for use these oversimplifying anecdotes? I think the better place to try to figure out what a sound theory of property requires, and then try to debunk the anecdotes that are bad, and to come up with other anecdotes that encapsulate what's good about the system. And then I like what Mark said. I think that there's a place for economic arguments and moral arguments, but when you're dealing with arguments in public opinion and political arguments. I think rights arguments have more bite in those realms. And so it's good, it's important for people who care about a robust and sustainable system of property to be able to say, you're claiming that this system is threatening other people's rights, well, here are the rights that your conduct is threatening as well.
I think we can take one last, because we went, oh, you want me to stop now? Okay, I'm sorry, that's all the time we have. I want to thank our panelists for a great discussion.